This is the first public hearing held by the Commission of Inquiry established by the Honourable Premier Michael Dunkley on the 24th of February 2016. Notice of the hearing was given by the first procedural statement published on 13 June 2016, and I welcome all present who have responded to it. Let me introduce myself as Chairman of the Commission and my fellow members, who are Mr. John Barrett, Ms. Fiona Luck, and Mr. Kumi Bradshaw. Alberta Dyer-Tucker is the Secretary to the Commission, and in the formal language of the Commissions of Inquiry Act 1935, she is the clerk appointed under Section 5. Jane Brett is her alternate, and both are here today. As Chairman and on behalf of the Commission, I have appointed Messrs. Narinder Hagen and Geoffrey Elkinson of the firm Conyers, Dill and Pearman Limited as counsel to the inquiry. The Commission has established a website. Throughout our proceedings, we will endeavour to update the website every working day when new information is available, and we shall expect all interested persons to keep themselves informed by consulting the website on the same daily basis. Terms of reference, I need not read them verbatim, are grounded in the report of the Auditor General on the Consolidated Fund of the Government of Bermuda for the financial years that ended on 31st of March in 2010, 2011, and 2012 respectively, specifically with regard to any matters arising under Section 3 of the report. Section 3, therefore, is fundamental to our inquiry. As it is published on our website, I need not quote it here. It lists the observations and recommendations made by the Auditor General in the light of the audits, limited to, quote, those matters arising from the audits which are significant enough to warrant the attention of the House of Assembly, close quotes. And it adds the grave warning, quote, many of the observations point to a general failure to follow the rules, financial instructions established by government for the safeguarding of public assets, close quotes. We are appointed, of course, by the Honourable Premier with the terms of reference I have referred to above. We are not acting as or on behalf of the House of Assembly, as was envisaged by the Auditor General in that passage from her report. I should emphasize that we are conducting an impartial, independent judicial inquiry pursuant to the 1935 Act, and that we shall make our proceedings as transparent as we properly can. Our starting point, therefore, is the Auditor General's observation that there appeared to have been, during the relevant period, a general failure to follow financial instructions which were described as the rules established by the government for the safeguarding of public assets. The financial instructions have been revised from time to time, and we must be careful to identify the rules that were in force during the relevant period of 3 financial years ending on 31st March 2012 and during any relevant earlier period. It will also be necessary for us to take note of amendments that have been made to the financial instructions since the 31st of March 2012, because our terms of reference include making recommendations for the future. Paragraph 7 reads, consider the adequacy of current safeguards and the system of financial accountability for the Government of Bermuda. 8. Make recommendations to prevent and or to reduce the risk of recurrences of any violation identified and to mitigate financial, operational and reputational risks to the Government of Bermuda. The introduction to Section 3 of the report also notes that the Permanent Secretary of Public Works is the accounting officer for all capital development projects except, and the exception may be important, quote, except those delegated by the Minister of Finance to another ministry, end quotes. Such delegation appears to have occurred, it did in fact occur, in relation to several of the projects that are relevant to our inquiry, and we must take that into account as we seek to identify the relevant accounting officer in each case, and more generally, the senior personnel who bore ministerial or other responsibility for each project. Section 3 of the report also noted that the Ministry of Works and Engineering was also required to follow its own internal management policies and procedures set out in PFA 2000, that's purchasing of goods and materials, and PFA 2002, procurement of contract services. Before proceeding further to identify the issues we must inquire into, I should refer to the scope of inquiry as defined in our terms of reference, paragraph 1, supplemented by paragraph 9. These read, Scope of Inquiry 1, inquire into any potential violation of law or regulations, including the civil service conditions of employment and code of conduct, financial instructions, and ministerial code of conduct by any person or entity which the Commission considers significant, and determine how such violations arose. Any other matter, 9, consider any other matter which the Commission considers relevant to any of the foregoing. Close quotes. I should also note that paragraphs 2 to 5 inclusive of the terms of reference under the heading, quote, references to other agencies, unquote, require us to refer, quote, any evidence of possible criminal activity, close quotes, to the Director of Public Prosecutions and to the police, and of, quote, possible disciplinary offences, close quotes, to the head of the civil service, that's paragraph 3, and to draw to the attention of the Ministers of Finance and of Legal Affairs, respectively, any matters that may be appropriate for surcharge or for civil asset recovery. Issues for the inquiry. Having regard to the terms of reference, the Commission should stress that it is clear that we are not required to resolve specific issues, whether of criminal or other liability, but rather to inquire into the conduct of governmental affairs during the period in question, and where relevant, either before or after that period, in relation to matters that are referred to in section 3, and where we consider it appropriate to refer, quote, any potential violation of law or regulations, close quotes, to the appropriate agency. In short, was the Auditor General correct? If so, how did that occur, and why was the situation allowed to continue? 3, what can be done to prevent it happening in the future? Now we find that section 3 contains 17 headings, numbered 3.1 to 3.17, and that these can be subdivided into 2 groups. The first group consists of transactions which involved third parties outside the government, whether as contracting parties or as recipients of payments made by the government, or as both. These headings are 3.1, failure to comply with instructions and related rules, listing individual projects under subparagraphs 3.1.1 to 3.1.7. 3.2, millions paid without signed contracts or agreements. 3.3, significant contracts not tendered. 3.4, duplicate payments. 3.5, overpayments. 3.12, millions paid for professional services without prior approval. We shall refer to these 6 headings as third-party issues. The remaining headings in section 3 are concerned with what we may call internal governmental, accounting or procedural issues, where it is not alleged except possibly under headings 3.7, 3.8 and 3.17, that the failure to comply with relevant standards resulted in improper payments or overpayments to third parties or in direct financial loss to the government itself. The relevant paragraphs are then listed. I needn't read out the titles, but they are sections 3.6, 3.7, 3.8, 3.9, 3.10, 3.11, 3.13, 3.14, 3.15, 3.16, and 3.17. These may be referred to as internal accounting stroke procedural issues. Now, dealing first with those internal accounting and procedural issues, the inquiry will look into the internal accounting procedural issues and in particular on whether the alleged deficiencies have now been redressed, and if not, why not. This will involve scrutinizing the mechanics of government, and it is an important aspect of the inquiry. These are important issues, and the inquiry will wish to scrutinize what the departments have done in response to the criticisms levelled in the report. We want to be assured that the government has learned and moved on from any past mistakes about its own internal processes. Third-party issues. Much of the Commission's time will be devoted to third-party issues. This is an area of obvious public concern. One of the principal complaints made in the Auditor General's report concerns the way in which large and important government contracts were awarded without the appropriate or any tender process. The Commission will likely focus, at least initially, on how these contracts came to be awarded as they were. The essential first stage, therefore, is to identify the contracts and projects where the Auditor General's report suggests that relevant financial instructions were not complied with in this respect. Some of these, for example, in subsections 3.1.1 to 3.1.7, are referred to by name. Others, for example, in paragraph 3.3, are defined only by reference to the government departments concerned and on the basis of samples which the report describes. These may include a large number of contracts, not all and perhaps not many of which are directly relevant to our inquiry. We therefore have to proceed initially, at least, on a selective basis. In making our selections, we will consider and be guided by the evidence provided by those involved in the transactions, as well as the size of the contract, and also the way in which financial instructions are said to have been breached. Individual members of the Commission and our Counsel, after thorough perusal of the Auditor General's files, have already identified a number of contracts and projects on which we can focus at the outset. That has been done with the considerable assistance of the former and the present Auditor General and of their office, and we have notified potential witnesses accordingly. This is an ongoing and indeed urgent process, and we shall be greatly assisted if interested persons and potential witnesses can inform us as soon as possible whether they will challenge either the validity of the sampling process used by the Auditor General in subsections 3.2, 3.3 and 3.12, or the accuracy of the figures shown in tables 5 to 10 of her report. That is in addition, of course, to providing us where they can with further informations about contracts and projects falling within the report. Paragraph 9 of our terms of reference includes any other matter which the Commission considers relevant to any of the foregoing. Our present provisional view is that we will be assisted by considering certain government contracts that were awarded before or after the period of financial years 2010 to 2012, where either payments made during those years represented government outgoings under earlier contracts, or the government's practice during financial years 2010 to 12 may have emerged before the period began and may have continued after it ended. For those reasons, we propose to inquire into contracts where questions may arise with respect to the award of the contract and the tendering process in respect of 1. The TCD Emissions Centre, 2. the Port Royal Golf Course, 3. the Dame Lois Brown Evans Building, 4. Heritage Wharf, and 5. the current airport development. In considering the tendering processes, the Commission will likely consider the following particular questions in relation to each contract. 1. Was the contract properly tendered in accordance with the financials instructions? 2. Were there any links between the successful bidder and the government or individual members of the government or civil service, such as to cause concern and warrant further investigation? While the focus, at least initially, will be on the tendering process, the scope of the inquiry may extend beyond the tendering process in some cases. The Commission may, for example, also consider how certain contracts were administered. Some of the projects involved large cost overruns. The Commission may, in the course of its inquiry, consider how such overruns arose. Throughout its inquiry into the third-party issues, the Commission will have in mind what lessons can be learned. Generally, throughout its inquiry, the Commission will have in mind what lessons can be learned from the alleged shortcomings that the Auditor General has identified. Our principal aim will be to discover why financial instructions were not followed and to what extent the situation has been remedied, and to make practical recommendations for the future. Our principal aim is to discover why financial instructions were not always followed and make practical recommendations. I will now say a few words about witnesses. The Commission appreciates the difficulty and pressure many people will feel about giving evidence to the inquiry. The Commission takes these matters seriously. The Commission has many powers, such as the power to compel people to give evidence. We also have the power, in exceptional cases, to preserve the confidentiality and the privacy of individual witnesses who request it. I strongly urge any person who may be able to assist us to come forward, whether in person or by posting information on our website. Today is the first public hearing. I have outlined above what the Commission presently sees as the scope of its inquiry going forward. Next, Counsel for the Commission will set out our provisional timetable leading to a witness hearing that will take place on Wednesday, 28 September 2016 and scheduled to continue until Tuesday, 11th of October, and longer if necessary. The second purpose of today's hearing is to enable us to hear any applications that may be made by interested parties, whether for the right to appear or be represented at the inquiry, or arising out of what I have said and what Counsel for the inquiry will say, or regarding any other relevant matter. Mr. Hagen.
Thank you, Mr. Chairman. As suggested, I would like to say a few words summarising what actions we, as Counsel to the Commission, have taken in order to assist the Commission in its inquiry, and what steps which we think are required prior to examining witnesses at the public hearing which you have just outlined. I should like to say at the outset that all the work which we have undertaken, which is designed to assist you in discharging your duty to inquire into the matters set out in the terms of reference and identified by you in detail in the opening statement which you have just given. I should also like to say that the context in which we have approached this work is on the basis that the Commission is involved in an inquisitorial process, and we are seeking to assist the Commission in gathering documentary material from the relevant government departments and third parties, and where possible and desirable, to obtain witness statements from the relevant individuals. Our role is to search out, analyze, and produce for you the material and evidence which relates to the matters you may wish to consider. We've been mindful of the Commission's responsibility to act fairly in regard to all of those affected by its work. In doing so, in doing this work on your behalf, we of course take no side. And given the scope of the inquiry and the responsibility to act fairly, the gathering of evidence in terms of documentary material and witness statements has been time-consuming, and we anticipate that it will continue to do so. We have approached our task by having a number of meetings with the Auditor General and our staff. We have received documentation provided to us by the Auditor General, which we have reviewed, and that in turn has led us to make further requests of documentation from the relevant government departments. We also had preliminary discussions with a number of individuals who we anticipate will be giving evidence in relation to the issues to which you have referred. As a result of the preliminary review of the documents and discussion with some of the relevant witnesses, we have written to a number of government departments seeking answers to specific questions and requesting specific documentation. We have requested that the information and the documents be provided to the Commission by 30th of June 2016. Now, that date is quite important, because if these dates slip, then of course the preparation and examination of witnesses at the date specified will be affected. We have made these requests to the Cabinet Office, the Office of the Tax Commissioner, the Ministry of Finance, the Ministry of Tourism, the Ministry of Education, the Ministry of Public Works, and the Accountant General. By these requests, we have sought specific documentation in relation to a number of projects, and they include the Commercial Court, the Ministry of Finance renovation contract in 2009, maintenance and store building contract in 2010, purchase of sand and rock in 2010, renovation of Department of Human Resources, Central Laboratory contract, GET security arrangements, Global Hue contractual arrangements, Ambling Development Services and its contractual arrangements, and Bermuda Emission contractual arrangements. We anticipate that upon receipt of this information and documentation by the 30th of June 2016, further questions may be requested from the government departments, and further documentation may also be requested. We also seek information and documentation from third parties, that is, other than the government departments, relating to tendering and ownership. The Commission has also decided, and Mr. Chairman, you've conferred this morning, to consider additional projects, and accordingly we will be writing this week to the relevant departments to obtain the necessary documentation for these projects as well. As you indicated, these projects include the TCD Emission Centre, Port Royal Golf Course, Dame Lois Brown Evans Building, and Heritage Wharf, and the current airport development. At the same time, we intend to send each witness a request for statement in respect of specified questions, As indicated by you, such a witness will be offered our assistance if requested in producing the witness statement. We also intend to provide each witness with a binder of document which may be relevant to his or her witness statement. This is clearly dependent upon the receipt of the document from the relevant government departments, and in this context, the dates are important. We anticipate that the process for taking voluntary witness statements should be completed by the end of July 2016. If a witness is not prepared to give voluntary statements, the witness is expected and, if necessary, will be required to appear at the hearing and will be examined in relation to the relevant issues by counsel to the Commission. We will undertake to produce a hearing schedule so that, as far as possible, witnesses will know when other witnesses may be called to give evidence at the hearing. We anticipate that the witnesses and other parties may make procedural applications to the Commission. These applications may include representation by counsel under Section 12 of the Commission of Inquiry Act 1935, applications to be added as a party, applications to give evidence in private. These and other applications should be made in writing and addressed to the Commission as soon as possible, and in any event, no later than 14 days prior to the public hearing which you have indicated. On the basis of this schedule, it should be possible for the witnesses to give evidence at the public hearing in accordance with the Commission's proposed timetable of hearings. Thank you, Mr. Chairman.
Yes. Madam, would you like to identify yourself and make any applications you have in mind?
Good morning, Mr. Chairman and members of the panel. My name is Venus Mamari of Liberty Law Chambers Limited, and I have been asked by BPSU to assist 10 civil servants in connection with this inquiry. I do have, for ease of reference, a list of those civil servants whom I had written to you about before, but shall I pass it to...
Thank you. Mr. Hagen's got a copy of this. Yes.
Mr. Chairman, I would like to make an application pursuant to Section 12 of the 1935 Act for leave for these civil servants to be represented at the inquiry. And I wonder, since this is a public inquiry, should I actually name them in my
I don't think there's any need to, unless you want to.
No, not at all. So, Mr. Chairman, in response, each witness, these witnesses received a letter from the Commission on 5th of May, 2016, indicating that each is a person who may be able to assist the Commission. They were informed that they may be requested to attend the sitting of the Commission at the time, commencing on 27th of June. In response, each witness wrote to the Commission directly confirming that they will attend the hearing. In the Commission's update published on 11th of April 2016, certain paragraphs of Section 3, which you have quoted this morning, were highlighted as the primary focus of the Commission. And as indicated in previous publications and this morning, we understand that a Commission bundle is being prepared and will be provided to these witnesses. We've had several very helpful discussions with Mr. Elkinson, and it is generally agreed that at this stage, it is simply not known which category of person these witnesses will fall into, meaning whether they require the Commission's leave to be legally represented or whether they're entitled to legal representation as of right.
Yeah.
So, subsequent to the initial letters that these witnesses received, 3 of these witnesses, in their capacities as heads of department, have also been asked to provide documents to which they have access within their respective departments.
Could you just give us numbers for those three on your list of 10?
Yes.
What are they? Numbers?
On numbers?
Yeah.
3, 5, 6. And at the time that we wrote to the Commission, we were not instructed with respect to number 3, since which we have been asked to assist.
And am I right in saying those letters were written essentially to heads of department?
That's correct.
Thank you.
So, Mr. Chairman, you will recall that they were, in addition to providing certain documents, they were also asked to provide simple written responses to the questions that were posed in those letters. And they were advised that they will be given access to the Commission's counsel to assist in the drafting of a witness statement, should that become necessary.
Yeah.
Mr. Chairman, we respectfully submit that these two apparently different hats that these witnesses are being asked to wear under these circumstances are hardly distinguishable. Having regard to the Commission's terms of reference as they relate to the Commission's power to refer any evidence of possible criminal activity to the DPP and police, and any evidence of public disciplinary offenses to the head of civil service, and the consequences that may flow from such referrals, it's only fair and just that these witnesses have leave to be represented at the hearing. We therefore respectfully seek the Commission's leave to represent all 10 civil servants at the Commission sitting in September.
Thank you very much. I just like, before I ask Mr. Hagen to respond, I just wanted to confirm two things. I don't have section 12 in front of me, but I think it uses a phrase equivalent to are interested in or concerned in the... Concerned in the matter of inquiry. Well, our present provisional view, and which I doubt will be challenged, is that almost by definition, anyone to whom the Commission has already written, inviting them to assist by giving evidence, clearly must, on the face of it, be a person who comes within that category. Otherwise, we wouldn't have written to them.
I'm grateful.
And so I make that observation first. Subject to anything Mr. Hagen would say, we're not really concerned with giving you leave today, because in our present view, those persons are entitled. I just want to say something again before Mr. Hagen responds. The three you've mentioned who've been written to as heads of department,
yes.
I think it's right to say that what we've tried to do is as follows. All 10 of them were written to as potential witnesses in their individual capacities.
9 of them.
Or 9, is it?
Mr. Chair, yes. 9 except for number 3.
I see, yes. So in number 3 case, there's no conflict anyway.
No, sir.
No. But insofar as we've also written to those 2 or 3 as heads of department, the request is rather different. It's saying, will you as head of the department produce whatever documents you have? And secondly, there are specific questions to be answered by the department.
Yes.
It should be possible to distinguish the personal involvement from the official involvement as head of the department. And I don't know whether you've been able to discuss this with Mr. Harden, but in principle, we are inclined to say straight away, if any of these individuals feel embarrassed by the overlap between their personal and their official positions, then we would have thought it was easy to identify somebody else within the department who could speak on behalf of the department.
I'm obliged.
But those are only preliminary observations, and I'll ask Mr. Hagen if he wants to respond.
Mr. Chairman, with respect, I agree with what you've expressed as preliminary observations. In relation to the 9 individuals who were written as potential witnesses, in our respectful submission, they clearly are entitled to representation, given that Section 12 speaks in terms of any person whose conduct of the subject of inquiry under the Act, or who is in any way implicated or concerned in the matter under inquiry shall be entitled to be represented by counsel. So in our submission, the application is well-founded if that is what these individuals wish to do. Secondly, in relation to the issue of the letters which were written to the heads of department, those letters were not written in their individual capacity. They were simply written to the official who happens to occupy the post of the head of the department. And in that context, that's an entirely different matter. In principle, I would not have thought that that requires representation. That is simply asking a government department to produce the documents which are in its possession at the time.
Thank you. Well, there is effectively no opposition to your application that the 9 persons shall be entitled to be represented by counsel under Section 12 of the Act. That has not involved any exercise of discretion on our part, merely applying the Act as it stands. I just wanted to add this footnote, or 2 footnotes. First, I'm sure you appreciate that we, as we see it, have no jurisdiction to deal with the costs of representation, and we certainly don't express any view on that matter.
I'm obliged.
Thank you. The second footnote is this, that we have a general aim. It would be premature to define it at this stage, but we have a general aim that as we become more familiar with the documentation and counsel has been able to obtain witness statements, we will do our best to limit the scope of their oral evidence by reducing as much as possible into writing in a way which can be agreed beforehand. I'm sure I needn't expand on that, but if a witness is in a position to produce documents dealing with a particular transaction, and there is no dispute about that transaction or that witness's involvement in it, either it will not be necessary for that witness to appear to give evidence if there's an agreed statement beforehand, or the scope of that person's evidence can be limited accordingly. And counsel, I know, are well aware of the importance of trying to achieve that when we reach the stage the documents are available and the agreed statement of facts can be drafted. Just one other matter. I want to safeguard against any suggestion that this might involve, or no, let me put it in the form of a question to you. Can you say now, is it envisaged that these people will be represented by just one counsel?
That's correct.
Yes. In which case the difficulty that might arise, were you to say each of them is entitled to a separate counsel, won't arise. We obviously would be very concerned if it was intended to have separate representation for each of these.
That is correct, except that I would say at this early stage, it'll be difficult to be able to identify any potential conflict of interest.
Yeah.
If that arises, then I would be duty-bound to address that.
Yeah.
In which case, legal representation, separate legal representation may be required.
Yes. Well, I think we bear in mind that you're entitled, or these 9 are entitled to be represented, but there would still be room for the Commission to exercise a discretion as to whether they need to be separately represented, and in particular, if they are if more than one counsel is involved, whether it's necessary for all of those counsel to be present for the whole of the proceedings. The action does, the section does use the words "the whole of the inquiry."
Yes, that's correct.
But on the other hand, I don't think we would want to see an obvious waste or duplication of effort if more than one counsel was involved by being present at times when they clearly weren't required.
That's absolutely correct. Mr.
So
Chair.
can we leave it?
Barring conflict of interest.
Yeah, a subject.
Well,
Can we leave it then that we give leave, or we don't give leave, we accept that these 9 persons are entitled to be represented by counsel under Section 12 of the Act, but we would expect you to notify us if any potential conflict of interest arises, which might mean that more than one counsel should be employed.
That's correct. I will. Thank you.
Good. Well, is there anything more you want to say on that topic, Mr. Hagen? No. Good. Well, now, do you have any more applications? Is that your only application today?
No, Mr. Chairman.
Yes. I think I'd like to say this for the benefit of persons who aren't here and aren't represented. The Commission is concerned that any person who, within the words of the Act, feels that they are involved in the subject matter of the inquiry ought to recognise that they are free to come forward, not necessarily to ask to be represented by counsel, but if there is such a person who would wish to appear before us, then that person must make an appropriate application to us in writing so that they can be regarded as a party to the inquiry in future proceedings. Good. Nothing else?
No, Mr. Chairman.
Nothing else, Mr. Howard. Well, on that basis, we formally adjourn this first public hearing to the witness hearing, which we will commence on Wednesday, the 28th of September at 10 a.m. in this room.